All right, folks, welcome back to part 2 of our presentation, where we will hear our experts discuss the impact of the Nuremberg trials on accountability for conduct under the law of armed conflict. First up, Professor Jeff Korn joins us via Zoom this morning from South Texas College of Law, just in case it was confusing, since it's very prominently displayed right there. Jeff is one half of the venerable Brothers Korn, but no stranger here to the Legal Center and School. He is a habitual offender, I suppose, sir, constantly supporting our events and offering his incredible perspective on a wide variety of law of armed conflict topics. His litany of accomplishments is legion and includes graduating from George Washington School of Law with highest honors, earning an LLM here at the Legal Center and School as the distinguished graduate from his class. He has authored several key texts on international humanitarian law, and most impressive, he survived an entire career in the JAG Corps and then successfully made the transition to academia, somehow having avoided the prefrontal lobotomy that we're supposed to get as field grade officers. But, sir, thank you very much for joining us, and we look forward to hearing your presentation.
There we go. Thank you for the introduction, and thank you for the opportunity to contribute to this event. It's nice to see all of you. I'm used to doing Zoom classes, but it is a bit of a change to see so many people in uniform and so many people sign in right at 9:30 when they're supposed to. If you're in academia, things work a little differently. I think this is a great event, and obviously I was excited to get the opportunity to participate. I wish I were there. I'm not there because of some commitments I have here. It was no fault of the organizers who worked very hard to get me there. So I want to thank them again and thank all of you for your attention. What I want to talk about is an article that I just finished with a friend, colleague, and also alum of the JAG graduate course, Lieutenant Colonel retired Rachel Van Landingham, who is an Air Force officer now teaching law at Southwestern Law School in Los Angeles. And about a year ago, we were together and I asked her a question. I said, isn't it kind of odd that Congress has enumerated a war crimes code for our enemies, but has not incorporated something similar into the punitive articles of the UCMJ? And that got us thinking about resurrecting an issue that's been periodically discussed, which is whether it is time for Congress to do just that, to incorporate war crimes as enumerated offenses in the UCMJ to enable commanders to have a more feasible approach to holding our own service members accountable for battlefield misconduct or wartime misconduct when it actually violates the laws and customs of war. Now, the general topic of your symposium is what is the impact of the Nuremberg legacy on accountability? And in fact, when I think about that question, I think the real impact of Nuremberg is that we shouldn't have needed Nuremberg. We shouldn't have a Nuremberg for two reasons. Number one, leaders in the armed forces, in all armed forces, should be fully committed to ensuring that their subordinates comply with the laws and customs of war. Certainly that's a principal obligation that you bear as legal advisors in operations, as legal advisors in training, in order to facilitate the commander's capacity to implement that responsibility of command. And in fact, when I think of the term command responsibility, I don't instinctively gravitate towards the mode of criminal liability that it's understood to represent for most international and military lawyers. I think of the kind of responsibility of commanders to make sure that we never get to a point where we need to do war crimes prosecutions. I think the other aspect of the legacy of Nuremberg, that we shouldn't need a tribunal like Nuremberg or any international tribunal, is that when there is misconduct within the ranks of the armed forces, the military is committed to holding its members accountable. Now, The United States military, as you all know, has a seemingly unwavering commitment and an absolute commitment for ensuring effective accountability for wartime misconduct. This is widely misunderstood, I think. There are many observers who assume that anytime there's a report of an incident of wartime misconduct, it should result in a criminal trial and a conviction. But all of you know that that's an unrealistic expectation. There are two bodies of law operating here that are not operating completely in sync. The law of armed conflict or international humanitarian law and international criminal law. And translating international humanitarian law into criminal responsibility is a complicated and challenging task. You could have many situations where a commander would conclude that there were mistakes made by subordinates, that those mistakes were inconsistent with the law of armed conflict, but based on the advice of legal advisors, the commander would conclude that the ability to satisfy the criminal burden of proof in a criminal prosecution is just not feasible. And this is a challenge for all international and domestic criminal tribunals that want to punish individuals for violating the rules of war, so to speak. I was on a conference yesterday with ASIL where we were talking about this, and we had some experts on international criminal law, and they made this point that in some ways, when you try and translate a battlefield regulatory norm into a norm of criminal responsibility, it's like putting a square peg into a round hole. It's not easy because the standards are different, and we need to understand that. Now, part of the solution for that for the U.S. military, as you all know, and I believe, has been a long-standing tradition that when we have service members who engage in misconduct that would amount to a violation of the law of war, we charge it under the punitive articles of the UCMJ as a crime derived from the kind of common law crimes in the code: murder, assault, mayhem, arson, larceny, whatever the crime may be. And this is, I mean, I was in the grad course in 1996 doing the seminars that you guys are doing, and this is what we talked about, that this makes good sense. If I'm a military prosecutor, why do I want to go through the headache of having to deal with kind of jurisdictional questions and vagaries of international law to prosecute a service member when it's so much easier to simply allege a violation of the punitive articles that currently exist? Now, as some of you may know, the option of charging a war crime has always been part of the UCMJ. As a matter of fact, it predates the UCMJ. It was incorporated into the Articles of War, I think, in 1917, both for the Army and the Navy. But Article 18 of the UCMJ vests a general court-martial with jurisdiction over two categories of offenses. Offenses in violation of the punitive articles, but only individuals subject to Article 2 are subject to that jurisdiction. But the second clause of Article 18 also vests the general court-martial with jurisdiction over any person who violates the law of war and is subject to trial by a military tribunal. So theoretically, as prosecutors, you've always had the potential to allege a violation of the laws and customs of war. But to my knowledge, we've never done that. Not for our service members who commit violations of the law of war in a situation where we could, in fact, allege and prove a war crime per se. So the question becomes, why tinker with that? In other words, if it ain't broke, why should we worry about fixing it? And I think the answer turns on changes in the international perception of what right looks like when you're dealing with misconduct that would qualify as a war crime. It comes from the fact that there is increasing scrutiny by supranational international tribunals like the International Criminal Court over accountability for war crimes. And it comes from the basic change in the way our own military thinks about the role of legitimacy as an enabler to operational and strategic success. So I think that the situation has changed. I started my career as an intelligence officer, and my job was to do the intelligence preparation of the battlefield. And when if we were doing the intelligence preparation of the battlefield on how to prosecute a war crime back in 1996, I think it made sense that these were rare events. We were not a military that was involved in kind of a constant state of combat operations. And so when you had the odd incident of battlefield misconduct that would qualify as a war crime, it was okay to use the punitive articles. There wasn't going to be a lot of attention on it, and the internal accountability would be credible and effective. That's not the situation anymore. The intelligence preparation of the battlefield has changed. And one of the most significant changes in my mind is the role of legitimacy as recognized in our own joint operational strategy. As most of you, or doctrine, as most of you know, Joint Publication 3-0 lists legitimacy as a key principle of effective joint operations. And how is legitimacy defined? Legitimacy is defined as the actual and perceived commitment to law, morality, and ethics by the force. So it's more than just the actual commitment, it's the perception of commitment. I don't know if any of you had the opportunity to watch BBC yesterday, but if you had watched it, the lead story was the report that was released by the Australian Armed Forces about the war crimes that their special operators appear to have been engaged in Afghanistan. And the chief of the Australian Defence Forces gave a presentation where he acknowledged that based on an extensive inquiry and investigation, there is strong evidence that there were a number of unlawful killings and abuse of detainees committed by Australian forces. This is worldwide news. The world is watching. Now, one of the questions he was asked was, what's Australia going to do about it? Are there going to be criminal investigations and prosecutions? And then there's this long, convoluted process of how you have to go through the military investigators, and then it has to be referred to a special prosecutor, and then it moves into a civilian court. And I'm watching that saying, if that happens in our forces, the process is much more efficient because it belongs to the commander, as all of you know, the commander who plays the role as the convening authority. But then I was wondering, and I think we all should wonder, if we were confronted with something similar, how is the perception of legitimacy going to be influenced by the inability or the practice of not charging an actual war crime? Or better yet, if our convening authority commander is concerned about legitimacy in the response to misconduct, should the commander have a more feasible mechanism to allege an actual war crime in lieu of a common law offense? So my view, our view in this article is the answer is yes. But there's also another development here that I think didn't exist when I was in your place in 1996. That is that Congress has done it. Congress has enumerated a war crimes code. Ironically, they've done it for our enemies, but not our own forces. And that really is what has us scratching our head. The Military Commission Act, as you know, of 2006 is amended in 2009 in response to the opinion in Hamdan v. Rumsfeld, enumerated the crimes that were within the jurisdiction of this military commission, this American War Crimes Tribunal. Why did Congress do that? Congress did that, to my knowledge, on the advice of the Judge Advocates General, who said the vagaries of the existing practice of charging war crimes under a general article, so to speak, under Article 21 of the code that invests the president with the discretion to convene a military commission to punish captured personnel for violating the laws of customs and war, is going to create just more litigation uncertainty. What we need is for Congress to be very clear on what crimes it believes are applicable to our captured enemy because they violated international law before they were captured. International law, as the United States understands it. So the punitive articles to the Military Commission Act are an enumeration of war crimes, and they are an enumeration of war crimes that ostensibly Congress and the executive believe are valid. So my question is, why not simply adopt the same approach for the UCMJ? If we did that, if we added to the punitive articles of the UCMJ the provisions of the Military Commission Act punitive articles, it would create a much more logical alignment between battlefield misconduct, the type of crimes that were at the focal point of the Nuremberg Tribunal, and the capacity or ability of a legal advisor to advise a commander acting as a convening authority that in this case we should charge the actual war crime. So that's the core of our proposal, is that Congress ought to enumerate war crimes for the punitive articles relatively analogous to the enumeration in the Military Commission Act. So the thesis of the paper is that it's perplexing and counterproductive for the perception of legitimacy that the U.S. would not enumerate a war crimes code for its own forces when it has done so for its captured enemy forces. Now, one of the challenging aspects of developing this thesis in the article was, does that mean we do a whole cloth migration of the punitive articles in the Military Commission Act into the UCMJ? And we don't think that that is the right approach for two reasons. Number one, there are some offenses in the Military Commission Act, as many of you know, that remain controversial in terms of their international law pedigree, right? If in your course you're studying war crimes, if you've read the Al-Balul Circuit Court en banc opinion, you see a relatively fractured opinion. The key opinion in that ultimate decision was then Judge, now Justice Kavanaugh, who referred to the validity of Congress, including in the Military Commission Act jurisdiction, war crimes that are consistent with what he called the American common law of war. In other words, they don't have to be war crimes recognized by the international community, as long as there is a tradition in American practice of alleging these crimes, then it's valid for Congress to incorporate them into the Military Commission Act jurisdiction. And the crimes that were most controversial, as most of you know, were conspiracy to violate the laws and customs of war, and the most controversial provision is material support to terrorism. Is material support to terrorism really a war crime? I think most international law experts, international criminal law experts would say no. Congress has said yes for the military commission. I don't think that it makes any sense to incorporate that into a war crimes code for our own forces, because if you think about it, if we were to determine that one of our soldiers engaged in material support to terrorism, then the proper offense would be aiding the enemy under the existing punitive articles, assuming the terrorist is an enemy group. Even if the terrorist was not an enemy group, there's actually a case that was decided, a court-martial that was tried at Fort Lewis when I was in my last assignment as an RDC, the trial of Specialist Ryan Hansen, I think his name was. Ryan, I can't remember his last name. He was a National Guard soldier who was caught up in a sting trying to give what he believed were undercover agents for Al-Qaeda information on how to disable and steal an M1 Abrams tank after he deployed to Iraq. And he was tried. The prosecutor was another friend of mine who's now a law professor, Chris Jenks. He was tried for a violation of Article 134, a crafted offense of aiding Al-Qaeda. The reason that they didn't charge him with aiding the enemy was because it was not clear that the evidence could establish conclusively that Al-Qaeda qualified as the enemy for purposes of the definition of the crime in the code, because Congress had never actually used the term Al-Qaeda in the 2001 AUMF. So was Al-Qaeda technically an enemy within the meaning of the offense? There was debate over that. So they crafted a violation, aiding Al-Qaeda, a terrorist organization engaged in hostilities against the United States. We don't need to include material support to terrorism or terrorism for that matter in the punitive articles that we would incorporate into the UCMJ. Conspiracy, I think, is a different beast. I actually think that there's validity in treating conspiracy to violate the law of war as a war crime per se, that it's more than just a mode of liability. And actually, I think it opens up an important kind of discussion on the validity of alleging inchoate versions of substantive war crimes. I think it's an area that's under-theorized, and I think it's an important area, and here's why. When we think of war crimes, our instinct is to gravitate towards result crimes. You attacked civilians. You murdered a prisoner. Crimes that are defined by the pernicious result. But in fact, effective accountability often requires accountability for conduct crimes. So you can have a situation where a commander launches an indiscriminate attack, but thankfully it doesn't have the harmful effect on the civilian population. Think of Hamas in a conflict with Israel, where they're just firing rockets indiscriminately. Now, Israel either will let them fall in an empty field, or the Patriot missile system will rapidly identify that they're heading for a population center and thankfully be able to take them down before they cause any harm. There's no unlawful result from that attack, but certainly as a conduct offense, it's worthy of condemnation. I think another one where that's interesting is perfidy. If you haven't studied perfidy, you'll learn that to establish the offense of perfidy under international criminal law, you have to prove that the perfidious conduct resulted in death, injury, or capture to the enemy. Well, is that really why we condemn perfidy? Do we condemn perfidy because of the result it produces? Or do we condemn perfidy because the conduct dilutes our confidence in respect for the laws and customs of war and therefore endangers the civilian population, like an enemy soldier who's fighting in a civilian uniform? What if he doesn't hurt anybody? Does that mean he should be immune from sanction? In my view, there should be more attention focused on the application of inchoate versions of law of war violations, conspiracy and attempt specifically, so that we have a better mechanism or a better ability to sanction conduct offenses as opposed to just result offenses. So I think conspiracy and including the attempt provision as it exists in the MCA should be incorporated into the punitive articles. There are some other aspects that I think the migration of most of the war crimes in the punitive articles of the MCA into the UCMJ would provide an opportunity to consider. One is closing the command responsibility gap. This is long overdue. This is not a new idea. Again, another one of my JAG school faculty colleagues, who's now a law professor, Professor Vic Hansen from New England School of Law, wrote about this some time ago. Under the punitive articles, if we're not charging a war crime and we have a commander who should have known that his subordinates were going to commit war crimes, we don't charge a Yamashita should have known theory of command responsibility. The best we're going to do is dereliction of duty. Why? Because if we're charging a punitive articles violation, the modes of liability are established by the aiding and abetting provisions. And the aiding and abetting provisions require proof of a shared criminal intent. So a commander's reckless failure to properly deal with a situation of a brewing war crimes incident would not satisfy that aiding and abetting mode of liability. This was what happened after My Lai, when Captain Medina, the company commander of the unit that committed the atrocity, was acquitted by his general court-martial. Why was he acquitted? Because he was charged as an aider and abetter, and the evidence was insufficient to establish that he shared the criminal intent. He was really responsible under the doctrine of command responsibility. Now, could we charge a commander with the substantive crimes of a subordinate based on the international law doctrine of command responsibility. Again, I think we could do that through the mechanism of the second clause of Article 18, but I believe that needs to be incorporated into the punitive articles of the UCMJ. And if you look at the responsibility provision of the MCA, it is in fact incorporated there. If you look at modes of liability in the MCA, they've incorporated the Yamashita theory of command responsibility into the code. So we think that this is an opportunity to address that shortfall. Another thing we address in the article is our belief that it would be credible for Congress to codify a mistake of law defense for battlefield misconduct. Now, you all know that mistake of law is rarely a viable defense. I was involved in a court-martial of an Army captain named Manulet, who killed a wounded detainee in Iraq. And Manulet was charged with assault with intent to commit murder. I'm not sure why they charged the assault, but probably the convening authority was trying to limit his liability. He was a good officer. He got in a firefight. There was a mortally wounded enemy. The medic said, "There's nothing I can do for him. He's going to die." And it was all on being recorded by a UAV. And Manulet said, "Step away." You saw him go like that, move away, and he shot him in the head and killed him. And Manulet, when he explained why he did it, he talked about a briefing he received from the JAG officer before they went to Iraq. And I was helping the defense counsel, who's a civilian defense counsel now in Germany, Will Hellickson. And we got the PowerPoint briefing for the PowerPoint slides for the briefing. And there was one slide that said unnecessary suffering. And then under it, all it said was do the right thing. That was his understanding of what unnecessary suffering meant. Well, maybe it was. We don't know. The judge denied him a mistake of law instruction because the judge said that the crime he was charged with doesn't require knowledge that the killing is unlawful, which is true. That's normally why you deny a mistake of law instruction. We don't think that mistake of law should be a purely subjective defense. What we're suggesting is that in the complexity of battlefield operations, a defendant should have the opportunity to at least plead an honest and objectively reasonable misunderstanding of his legal obligation or her legal obligation as it related to that alleged act of misconduct. I think it would rarely be successful. And in fact, I think if Captain Manulet had received that instruction, the court-martial may have still convicted him. But it seems odd to me that a soldier or a Marine or an airman could receive a legal briefing, and that legal briefing, for whatever reason, may have been misleading or even erroneous, and yet that fact could not factor in to the assessment of a criminal culpable state of mind if the service member is then subjected to a criminal prosecution. So I think it's worth thinking about if they're going to, if Congress were to do this. The last piece of this, which is really interesting, is getting rid of the amended Article 2, sub 13 of the current UCMJ. I don't know if any of you have taken a look at that. It kind of popped into the code, and I've been unable to figure out where it came from. Actually, was with General Petey a couple of years ago at a conference, and I said, "Do you know about this?" And my recollection is he said, "I don't think we had anything to do with adding that provision." I'm going to read to you what it says. Now, remember, what does Article 2 do? It subjects individuals to the punitive articles of the UCMJ, all of them: dereliction of duty, AWOL, disobedience to an officer, etc. Here's what it says. Included now in the list of individuals subject to Article 2 jurisdiction, individuals belonging to one of the 8 categories enumerated in Article 4 of the Convention relative to the treatment of prisoners of war who violate the law of war. That makes absolutely no sense. So what has Congress done? In Article 13, Congress has subjected our enemy to our military code before the enemy is ever captured. Now, obviously, once the enemy is captured, there's an existing provision of Article 2 that subjects the prisoner of war to military court-martial jurisdiction for good reason. But and then it says for violation of the law of war. But the law of war is not encompassed in Article 2 jurisdiction. It's completely confusing. I think what happened was that somebody in Congress or some staffer wanted to foreclose the opportunity of using a general court-martial as a criminal tribunal for unprivileged belligerents, wanted to ensure that unprivileged belligerent trials would remain in Guantanamo. So what does it purport to do? It purports to say that the only individuals who we capture, who we could court-martial, have to qualify for status under Article 4 of the Third Geneva Convention. But it's incoherent. It makes no sense. If Congress wants to limit the forum that's available for unprivileged belligerents alleged to have committed war crimes to the military commission, they should do that in Article 18. They should say in Article 18, a general court-martial has jurisdiction to prosecute any person who violates the law of war, except individuals who don't qualify as prisoners of war under Article 4 of the Third Geneva Convention. And by the way, I think that one of the benefits of including war crimes in the punitive articles is it would actually make it more likely that if we did capture an enemy who we believed violated the law of war before we captured that enemy, that we would use a general court-martial to prosecute that individual instead of creating a new tribunal to do it, which we've done so far. Why? Because it would be just so much easier. You would just look at the UCMJ, you'd have the articles, the war crimes incorporated in the code, the general court-martial would have jurisdiction under Article 18, and it would be a more feasible and, in my view, a more credible approach, because it would subject the enemy to the same process that we use for our own personnel. So ultimately, I think to advance our collective interest in enhancing the perception of legitimacy when we're dealing with misconduct in war, both by our own forces and by our captured opponents, it would be logical to give commanders the ability to look to the punitive articles of the UCMJ and charge those offenses for trial by general court-martial. And I'll finish with a quote from President Eisenhower, his second inaugural address. He said, "Whatever America hopes to bring to pass in the world must first come to pass in the heart of America." So if we want legitimacy and accountability to be fully embraced, I think that it's time for our Congress and our armed forces to fully embrace it by adopting a war crimes code and the punitive articles. And that leaves me about 13 minutes for questions and answers. So is there a moderator or do they just throw them out to me? Oh, please raise your blue hand. I see it. So let me try the first one. Why is it better to include MCA provisions into the law of war Article 96? Yeah, because they're more specific. You'll lay out all the elements. Congress can define the penalties, or the president can define the penalties, as is done now with the enumerated provisions of the UCMJ. Remember that the list of offenses that you have in the punitive articles, that's grown over time. I've been working on a project well, I don't want to go too deep into it, but reviewing the 1917 court-martial of the African-American regiment that was involved in a what was alleged to be a mutiny in Houston, Texas. It's called the Camp Logan Mutiny. It led to the largest court-martial in actually the largest criminal trial in American history. 63 defendants in the first trial were joined for one court-martial. They were represented by a major who wasn't even a lawyer, so one representative for 63 defendants, and 13 of them were sentenced to death. Basically, if you were an NCO, you got sentenced to death. They were hung within 2 weeks at Fort Sam Houston with no review whatsoever other than convening authority approval. It created a firestorm. It was the origins of our own military appellate process. But in this project, I've had to go back and look at the Articles of War. The Articles of War, in terms of the enumerated crimes, were very limited. A lot of crimes were derived from the general article. So what you see in the punitive articles today is the result of decades of congressional and military recognition that effective criminal accountability is enhanced by more detail as opposed to generality. And I think the same principle would apply to the UCMJ as it relates to war crimes.
We'll take a question from the audience next. If anybody has a question within the audience of Decker, please raise your hand.
Hey, sir. Good afternoon or good morning. This is Major Chris Whalen, United States Marine Corps.
Hi.
Question in terms of if adopted and a war crimes statute was adopted as a separate punitive article, what would be the triggering mechanism for applicability? An IAC and NIAC? I mean, when would you turn it on? When would you turn it off?
Well, if you look at the punitive articles in the MCA, every one of them has it as an element of the offense that the conduct occurred in the context of an armed conflict. And I think that, personally, I think that shouldn't be an element of the crime. That shouldn't be a fact finder's judgment. Isn't it kind of odd when you think about it that you're going to prosecute somebody for a war crime and one of the elements that you have to prove beyond a reasonable doubt to the fact finder is that it occurred in the context of an armed conflict? I think that's a jurisdictional issue. And I do believe that that would have to be part of the jurisdictional penumbra, that these offenses are applicable only in the context of an armed conflict. The MCA doesn't really draw a distinction between IAC and NIAC. Now, one point that I failed to raise, which your question raises, Major, is I don't think this is a binary option for the convening authority. I don't think the convening authority would be obligated. I wouldn't want that, to be obligated to use the war crimes offense. I think it would be an exercise of convening authority discretion. So if you were advising a convening authority and you had a situation where you just thought it would be, charging the war crime would create an unnecessarily complicated question of jurisdiction, then you would say, let's avoid that in this case and charge murder or charge manslaughter or whatever the case may be.
A question now from Decker Auditorium.
Hi, sir. This is Lieutenant Megan Moore from Decker. Thanks for speaking with us today. I'm just wondering if you could elaborate on the Yamashita theory and what that would look like in terms of a commanding officer knowing there was a brewing war crime and how that could be enumerated. Thank you.
So the Yamashita decision, ironically, by our Supreme Court, raised the question of whether General Yamashita could be accountable for the substantive war crimes committed by his subordinates. In other words, he was vicariously liable for the crimes committed by subordinates, not because he encouraged them, not because he intended and directed that those war crimes be committed. That would be easy. That's just classic accomplice liability. But because he should have known that these acts of misconduct were going to occur, and he failed to execute his responsibility as a commander to prevent them. This is known as the should have known theory of command responsibility. If you think about it, what it really means is that a commander may be liable as an accomplice. A commander may bear accomplice liability based on her reckless failure to discharge responsible command. In other words, the commander is aware there is a risk that war crimes will occur, and the commander doesn't take remedial measures, and therefore those war crimes are encouraged. Under classic aiding and abetting doctrine, which is incorporated into the punitive articles, you cannot convict somebody as an accomplice unless they share a criminal intent. I mean, all of you learned this in basic criminal law, right? You have to have the intent that the principal commit the crime. So there's a gap there. If we charge a soldier, let's take Lieutenant Calley. Lieutenant Calley was charged with a whole range of murders at My Lai. He ordered the murders. That's easy. The soldier committed the murder. He's responsible as an accomplice because his order shows he intended that crime to occur. Captain Medina, on the other hand, knew there were problems brewing in that platoon. There were incidents of less drastic war crimes that had been occurring, and Medina didn't do anything to correct the situation. Medina was acquitted because he was not an accomplice to the murders, because the evidence didn't prove he intended the subordinates to commit the crime. After your session today, go look at the aiding and abetting provision of the Military Commission Act, and you'll see incorporated in it is that an individual is responsible for the misconduct of subordinates if the individual should have known that the misconduct were to occur and didn't take appropriate remedial measures. I mean, this is something you'll advise your commanders on. So you'll have an act of maybe what we might call minor misconduct in battle. There's a detainee that gets shaken, or the situation where the Marines urinated on the dead Taliban bodies. Now, I don't think many of us are going to say we need to do a court-martial in that situation. On the other hand, you would say to the commander, if you don't do anything about it, if you ignore it, you're setting the conditions for more problems, because you're creating a command culture that is tolerant of misconduct of subordinates. That's the essence of the should have known liability under Yamashita, and it is not incorporated into our punitive articles today.
Sir, you referenced earlier the increasing scrutiny at the International Criminal Court is one of the purposes behind Congress enumerating war crimes in the ECMJ. And I understand the ICC is a court of last resort and that national authorities have the primary responsibility to investigate and prosecute crimes. Just could you expound on how the ICC scrutiny does or should impact U.S. national investigations and prosecutions?
Well, candidly, I don't believe it should impact it very much at all, because I think that people like you and the responsible commanders you advise have a self-interest and a military interest in being fair, but aggressive in accountability for misconduct in war. I mean, the idea that we need a supranational international tribunal to compel us to hold our subordinates accountable for battlefield misconduct, in my view, misses the whole point of what responsible military command is all about. Nobody has a stronger interest in holding subordinates accountable for violating the laws and customs of war than the commander, him or herself. Having said that, we know that there's an increasing perception in the international community that the right way to deal with war crimes is through some international tribunal that is staffed by civilian judges from all over the world. Look at the irony, if you will. You're learning about Nuremberg. Nuremberg was an IMT, an international military tribunal. There was a recognition that the efficacy of the process would be enhanced by entrusting military legal experts and military officers with the responsibility to deal with war crimes. That's no longer the case. My personal experience in a case called Prosecutor v. Gotovina in the Hague, where I was a defense witness for 4 days, was really shocking. I mean, this was a Croatian commander who was being prosecuted inter alia for conducting indiscriminate attacks with artillery assets into a city where the enemy had its headquarters and other vital installations. And the lack of understanding of basic military doctrine, basic military considerations, was almost shocking to me. He ended up being convicted on an arbitrary decision, and then the appellate chamber actually reversed the conviction and entered an acquittal. But what I'm suggesting is, if we know that there's increasing pressure from the external community to demonstrate your legitimacy and commitment to accountability, then I think addressing the crimes as non-war crimes is not a major, but a subtle self-inflicted wound. Because if you investigate war crimes, you prosecute war crimes, there's an acquittal for the war crime, the odds are that the broader international community, including hopefully the ICC prosecutor, will view that as a credible exercise of the primacy of domestic responsibility. Does that answer your question, Major?
Yes, sir. Thank you.
Thank you, Professor Korn. That is all the time that we have for questions. And thank you so much for your continued support of TJAG-LICS and taking the time from your teaching schedule to join us today.
Well, listen, I want to thank all of you. I admire what you're doing in this world of COVID more than any other time. It's got to be challenging. But I also would encourage you, as you move on to your next phase of your careers, to pick some topic that you're just really interested in and drill deep. Go deeper than the surface. I mean, that's one of the great opportunities of the grad course, that you get to kind of start developing your sense as a scholarly expert. Because the truth is, in this dialogue, we need voices like yours more than ever before. So I wish you all good luck. If any of you ever get a South Texas College of Law graduate as a subordinate, take care of her, him for me, because they love what they're doing in the services. And any Air Force JAGs out there, if you encounter a Captain Korn flying a drone sometime, that's my son, so take care of him. Thank you very much.
Next, I have the privilege of welcoming Professor Gary Solis. So I have a little story here. I was in my second year as an operational law observer coach trainer at the Joint Readiness Training Center, sir, when my boss said that it was like getting to hear Gary Solis talk about the law of armed conflict. And I replied, "Who, sir?" Sure enough, today I have the honor of introducing an expert in this field. I find myself relying upon your text in all of my classes, which is informed by your military service as a Marine Corps officer, judge advocate, military judge, professor at West Point, Georgetown, and expert to drafting committees and expert witness to the military commissions. Sir, you're the author of Sintang, an American war crime, and the textbook I referenced, The Law of Armed Conflict, currently in its 3rd edition?
In June.
In June. Please join me in welcoming Professor Solis.
Thank you very much. My notes. I first came to the JAG School in 1973 to take a course on the law of war. Oh my God. Just a second, they're in the other room. Nope. How are they? Yes, they are. Here they are. Okay. Ta-da. I first came to the JAG School in 1973 to take a law of war course from Jeff Korn. My dad, when I was a kid, told me 3 things. He said, don't ever eat at a place called Mom's, and never play cards with a guy named Doc, and don't ever follow Jeff Korn. And he's right. I mean, Jeff Korn, even when he was a captain here 40 years ago, spoke law in full paragraphs without notes. Guy's amazing. Well, you're getting the old school now. I got notes. There aren't many institutions recognizing that this year marks the 75th anniversary of the Nuremburg International Military Tribunal. The day after tomorrow, 21 November, it initially said 26 November in Fred's presentation, I think the 21st was, it doesn't matter, is the day that the Supreme Court Justice Robert Jackson faced the tribunal's 4 judges, and he said that the tribunal was, quote, one of the most significant tributes that power ever has paid to reason. World War II had ended. The Nazis surrendered on 8 May 1945, the Japanese 3 months later. American, British, French, and Russian military units were in Berlin as occupation forces. General Eisenhower, in cooperation with the 3 allies, the French, the British, and the Russians, established Allied Control Council. Now remember, this was right after the conclusion of the war. There was no operative law in Germany. And so the Allies had decided that they would be the operative law until law could be resurrected. And the Control Council, the Allied Control Council, was effectively the law in Germany at the time. And the goal, of course, was to bring back the German society. Soon, Army Lieutenant General Lucius Clay arrived. He had been appointed the military governor of Germany and the commander of the Berlin U.S. zone. His mission, like that of the Allied Control Council, was to bring back a functioning German government. Well, General Eisenhower and General Clay were trying to figure out what the heck to do with the thousands of war criminals, Nazi war criminals, that they knew were in Germany, that they probably were holding in camps. Well, U.S. war crimes policy, as Fred mentioned, as Colonel Bork mentioned this morning, was guided by the 1945 Moscow Declaration and the 1945 London Agreement that had published the charter, the rules for the IMT. After the IMT concluded, Allied war crimes policy was executed under authority of Control Council Law Number 10. Each of the occupying powers was given authority under Control Council Law Number 10 to try Germans charged with war crimes, crimes against peace, and crimes against humanity. Now, as one of the speakers said this morning, initially there was a 4th one, and that was to try those who were in organizations that had been declared unlawful by the IMT. More on that in a moment. So now there would be new trials subsequent to the IMT. Law Number 10 directed that they were to be composed of tribunals before judges selected by the convening power. The U.S. had determined that merely trying a couple of dozen Nazi war criminals wasn't sufficient to fully serve justice. The German people must see that their fate was the fault of the Nazi government and the Nazi military caste, to understand that German citizens had allowed the Nazis to flourish, change their lives, and destroy their nation. Public trials that would remove all doubt about the crimes charged by the Allies being anything other than fair and subjected to proof that the crimes charged by the Allies were in fact those crimes had been committed, not just by the military and political chiefs, but by Germany's senior lawyers, doctors, industrialists, civil servants, the enablers of Hitler's nationalist socialist party. Now, as Fred mentioned early on today, after World War II, U.S. war crimes were conducted on 3 levels. We know that 22 of the most senior criminals were tried at the International Military Tribunal. Justice Jackson was appointed by President Truman, and at the IMT, as you know, he had tried 22 Nazis. 19 of them were convicted, 13 were sentenced to be hanged. 3 of them were acquitted. Among the IMT's most notable rulings, it held that there was individual criminal responsibility for war crimes, as we've heard a couple of times this morning already, which had not been the case prior to the IMT. In addition, head of state immunity, active state, would no longer be recognized. The IMT would be followed by several trials. Like the IMT, these trials were to be held in the Nuremburg Palace of Justice. Today, they're referred to as the subsequent proceedings. Subsequent proceedings defendants were to be subordinate German leaders. Fred put it nicely, the not so important criminals. They would try senior administrators, leading industrialists, professional leaders and political foils that had enabled the Nazi machinery that murdered, stole, and perverted Germany to Nazi beliefs and ideals. They would be guided by Control Council Law Number 10. The significant difference between the International Military Tribunal and the subsequent proceedings is that the subsequent proceedings would be judged by long experienced legal professionals who would implement the IMT's judgment. And the IMT's 149-page judgment would be the subsequent proceedings stare decisis. Now, Colonel Bork and I were discussing after the first lecture this morning why they were civilian judges rather than military judges. Well, we can't know for sure. As far as I know, General Taylor or Justice Jackson have not commented on that. It's my opinion that we did that because we wanted the German populace to see that this was not just another military trial of the defeated enemy. This was a trial of civilian jurists who would implement the laws that we had enacted in the Control Council. There was a third level of war crime trials that was conducted by the U.S. Army at Dachau, a former Nazi death camp. The Dachau trials of lesser Nazis like concentration camp guards, policemen, minor officers, and soldiers, including SS Colonel Joachim Peiper, would be conducted under the rules and procedures of FM 27-10 of the day. Rules of land warfare, pretty simple. And under the Manual for Courts-Martial of 1928. This would be ordinary courts-martial at Dachau, conducted in extraordinary times with military judges and officer panels. Dachau eventually convicted 1,416 accused. Unfortunately, the interrogation techniques, particularly in the early trials, were conducted using torture and beatings, which puts serious doubt into the voluntariness of confessions and the validity of the trial's outcomes. After the IMT, the subsequent proceedings in the Dachau courts-martials, remaining suspects in the Nazi regime, political functionaries, Nazi officers, soldiers, were to be tried by what were known as denazification courts. And this covered thousands of potential accused. Now, originally, they were going to be tried by the proceedings, the subsequent proceedings. Fortunately, they were taken over by the German judicial system, which was newly arised under German national law. And this unexpected involvement of German courts was a major relief for U.S. prosecutors. But our focus, of course, is on the subsequent proceedings. They're not the forgotten trials, but they are the underappreciated trials. Their role was important in restoring Germany as a democratic nation and a vital post-war U.S. ally. They provided the basis for much of post-war international criminal law and for a degree of modern military law as well. Now, as we've heard, each subsequent proceeding was made up of 3 judges. 3 was not a magic number. We didn't have to have 3. We could have had 5. We could have had 1. We decided that 3 was the better number. 3 judges, civilians, who were designated by the military governor, then Lieutenant General Lucius Clay. These 32 civilian judges, recruited by the War Department in the U.S., were initially appointed by President Truman in his role as Commander-in-Chief. These 33 judges were independent and responsible only to themselves for their judicial actions and decisions. There was no appellate court at the time. Now, later on, General Clay reviewed every finding, every judgment of each court, and he reduced some sentences. But the civilian judges were on their own. That is to say, there was nobody looking over their appellate shoulder. 25 of the 32 judges were or had been state court judges. 1 was a law school dean. The other 6 were prominent attorneys. The qualification for tribunal judgment was 5 years of legal practice. Judicial experience was not required. Although no tribunal could consist solely of practicing attorneys, the presiding judge in each panel had to have been an experienced practicing judge. The first problem for the subsequent proceedings was, who should they try? Well, the bad guys, of course, but determining who the Nazi bad guys were and which of them should be tried was a tremendous task. This number, 12 subsequent proceedings, which was decided later, they didn't know initially how many there would be, couldn't come anywhere near to trying all of the Nazis suspected of war crimes, even if they were identified and could be located somewhere within post-war Europe. A modest source of help was located. For many months, the United Nations War Crime Commission had been compiling lists of suspects on the basis of information furnished by the countries that had been occupied by Germany. By the end of the war, these lists were very lengthy. Also, the basic directive regarding U.S. military government Germany, JCS 1067/6, was titled Directive on the Identification and Apprehension of Persons Suspected of War Crimes and Other Offenses. Now, 1067/6 also required General Eisenhower, the Commander-in-Chief of U.S. occupation forces in all Europe, to detain all persons suspected of any war crime, conspirators, principals, aiders and abettors. Soon after the war ended, the U.S. Army was holding 100,000 German suspects. Now, we could only try a very small number of those, of course. Those held, by the way, were not considered to be prisoners of war. They were held as suspected war criminals. Now, the charges to be brought by the subsequent proceedings were an easier matter. They were identified in Control Council number 10 itself. War crimes, occupation offenses, crimes against peace, and crimes against humanity. The same charges that we had seen at the Nuremberg International Military Tribunal. Now, first, General Telford Taylor, Jackson's successor, grouped the several varieties of war criminal enterprises into cases according to their sphere of activity, for lack of a better term. The sphere of activity in which the defendants were primarily engaged. That was a difficult process itself, and it had sometimes subtle differentiations. But eventually, Taylor came up with 12 subject matter trial categories that were the result, and you've seen those already. The medical case, the justice case, the hostage case, the ministry's case, the high command case, and so on. Identification of the crimes to be prosecuted and the subgrouping of potential defenses into the various criminal enterprise boxes narrowed the number of potential defendants significantly. Finally, an individual selection as a trial defendant was based on their level of responsibility and involvement in their criminal enterprise category. Now, actually, this is the kind of judgments that prosecutors make every day in courts. Who among this batch are we going to charge? So this was not a scientific assessment. It was what the office of the chief of counsel decided on their own. They were doing the best they could in a terrible time. The war hadn't been over for a year yet, and they were having to make these decisions. So, it may not have been scientific, but it was a pretty damn good start. The unique difference between Nuremberg was the Nuremberg IMT and the subsequent proceedings was the extremely large base of numbers of potential defendants and the enormity of their crimes. But the subsequent proceedings' legacy isn't found in their creation or the number of defendants that were tried. The subsequent proceedings do stand in the legal shadow of the IMT, and reasonably so. Not only was the IMT the world's first legal accounting for those who would make aggressive war, historic in itself, but it was the IMT that historically held, as we've already heard, that active state doctrine was dead, and that crimes against international were committed by men, not abstract entities like the state. And that law of war and international law is enforced only by punishing the men and women who violate that law, a holding that reinvigorated international criminal law for decades. But beyond those very significant holdings, there's remarkably little criminal law in the IMT judgment. Nothing on evidence and procedure, almost nothing on modes of participation, defenses, or sentencing. Even the judgment's discussion of the crimes themselves is relatively cursory. It was the subsequent proceedings which, by contrast, addressed those areas in detail. Those subsequent proceedings were conducted by 94 military prosecutors, 11 of whom were women. Those 94 prosecutors tried 12 cases involving 185 accused before 32 civilian jurists. It's the subsequent proceedings' contributions to the law of war and international criminal law that have had lasting impact. The proceedings' influence is seen in the International Criminal Court's Rome Statute, and particularly in the outstanding judgments of the International Criminal Tribunal for the former Yugoslavia. Examples of the trials, the proceedings' legal legacy are numerous. Take the New York Times. This is the front page of the New York Times of Thursday, September 17th this year. Saudi strikes in Yemen put U.S. in danger of war crimes. The civilian death toll from Saudi Arabia's disastrous air war over Yemen was steadily rising in 2016 when the State Department's office reached a startling conclusion. Did my mic just go dead? Okay. All right. Where was I? American officials had reached a startling conclusion. Top American officials could be charged with war crimes for approving bomb sales to the Saudis. U.S. officials say the legal risks have only grown as President Trump has made selling weapons to Saudi Arabia, the UAE, and other Middle Eastern nations a cornerstone of his foreign policy. It was clear that state and Defense Department officials had potential legal liability for aiding and abetting war crimes. U.S. officials have had full knowledge of the pattern of indiscriminate killing, which makes them legally vulnerable. Some State Department officials who shepherded arms sales overseas have discussed the possibility of being arrested while vacationing abroad. Well, can a U.S. Secretary of Defense on a state visit to, say, Germany, Spain, or Sweden, states that assert mandatory universal jurisdiction for war crimes, can he be arrested and tried for providing weapons to Saudi Arabia while knowing these weapons will be used against Yemeni civilians? A grave breach of Article 85 of 1977 Additional Protocol 1. Well, the answer turns on the court's definition of knowledge, whatever that court might be. Knowledge is not addressed in the Geneva Conventions or the additional protocols or the Manual for Courts Martial or the UCMJ. But the subsequent proceedings did address it in United States v. Pohl, referred to as the concentration camps case because all 18 defendants had some involvement with the death camps. One of the accused in Pohl was Rudolf Scheidt, a former SS colonel, and he was acquitted of war crimes against humanity, war crimes and crimes against humanity. The tribunal wrote in its judgment, the prosecution has offered no evidence that the defendant, Scheidt, had any knowledge of the criminal activities of the SS or that he remained in said organization with such knowledge. The tribunal's phrase, with such knowledge, comes to the rescue of the SecDef. The subsequent proceedings required actual knowledge of the unlawful usage. In SecDef's case, that he had actual knowledge that the U.S. weapons being sold to the Saudis would be unlawfully used to target civilians. And actual knowledge is a hard case to prove, particularly if the accused is a civilian, a political appointee, and with no physical connection to the weapon involved or the state wherein it's used. Yes, everyone here who reads the newspaper knows what the Saudis are doing with the weapons we sell them, but proving them is no easy task. The DoD Law of War Manual addresses knowledge in relation to command responsibility, and the manual casts a much wider net than actual knowledge. Did the commander know, or should she have known? Should she have known of the illegality involved in the weapons sale? All of the subsequent proceedings required actual knowledge rather than the broader negligence standard should have known. The subsequent proceedings have relevance in Army courts-martial. Some years ago, the issue of commanders' knowledge of subordinates' war crimes was crucial in the Army GCM of United States versus Captain Medina, the same case that Jeff referred to in the last talk. Medina was the CEO of Charlie Company, 1st Battalion, 20th Infantry, part of Task Force Barker, in the 1968 assault on My Lai 4. Captain Medina's 1st platoon was led by 2nd Lieutenant William Calley. Now, I presume you know the basics of the My Lai massacre of 350 to 400 Vietnamese civilians, and that Calley's GCM before Medina's trial resulted in Calley's sentence to confinement for life. Shortly after Calley's 1971 conviction, his company commander, Captain Medina, was tried, charged with being an aider and abettor to the premeditated murder of not fewer than 100 civilians. The trial counsel, no need to name him, requested an instruction to the members that to convict, they had to be convinced, BRD, that Medina had actual knowledge of Calley's crimes in My Lai. Well, actual knowledge was not then and is not today an element of aiding and abetting required by the Manual for Courts-Martial, the UCMJ, or the Military Judge's Bench Book. It was clear that the standard was not actual knowledge. Rather, it was the more inclusive negligence standard that the commander knew or should have known. This, of course, is in FM 27-10, paragraph 509, where it's directly stated. It's also in the today's DoD Law of War manual. Well, it's the more inclusive negligence standard, and several subsequent proceedings considered command responsibility, and that was their conclusion. In Captain Medina's case, on the basis of the trial counsel's unfamiliarity with Nuremburg and 27-10, the military judge gave the requested incorrect instruction with its erroneous standard. Now, Jeff suggested that he may have been acquitted anyway, which is true because the same trial counsel had mischarged him. Instead of charging him with command responsibility or negligence or some other offense, there was a number of other offenses that were possible. He chose the most difficult one he could pull from the manual, aiding and abetting, which requires that they share the mental intent. The members acquitted on all charges as a result. Another instance of forward-looking law applied by the subsequent proceedings. In 1940 FM 27-10, it stated that obedience to the orders of a superior is a complete defense. Individuals of the armed forces will not be punished for these offenses in case they were committed under the office orders or sanctions of their government or commanders. A complete defense. After the 1944 change to the manual, a one-page insert in most of the older manuals, obedience of order no longer was a complete defense. It was no longer a defense. It could be considered in mitigation in E&M, but the law had changed. The law changed, by the way, because, as Fred mentioned this morning, we were about to try the Germans for obedience to orders that they would raise as a defense. And in order to preclude that, we changed the FM. Well, the British made a similar adjustment to their law of war regs. Article 8 of the IMT's charter was blunt on this issue. The fact that the defendant acted pursuant to order of his government or a superior shall not free him from responsibility, but may be considered in mitigation. The defense of superior orders was effectively eliminated by the IMT. But the IMT apparently was uncomfortable with so confining a decision, despite its clearly being required by the charter. The IMT injected an unanticipated ameliorating factor that was not in keeping with its own charter. The true test, the tribunal noted, which is found in criminal law of most nations, is not the existence of the illegal order, but whether a moral choice was possible. The charters of the IMT and the subsequent proceedings regarding obedience are essentially identical. The subsequent proceedings, however, had many more opportunities to visit this courtroom liability of moral choice, the test informally modified by the IMT. The subsequent tribunals sought to resolve the matter by treating it as an issue of intent. Despite the two charters, subsequent proceedings cases uniformly required a showing of a lack of moral choice, i.e. duress, as a necessary part of any successful defense of superior orders. Consideration of the better reasons, more reasonable, and soon widely accepted moral choice test is apparent in the Flick and Farben subsequent proceeding judgments. And the subsequent proceedings, in going its own way and implementing what the IMT had given discussion rather than implementation, demonstrated, in my opinion, courage and independence and leads legal and moral authority to their judgments. Today's DoD Law of War Manual follows the subsequent proceedings lead, holding that a person acted pursuant to orders of his or her government or of a superior does not relieve that person from responsibility, providing it was possible for that person to make a moral choice, using the very words of the subsequent proceedings. There are other instances of the subsequent proceedings' forward-looking exercise of legal judgment. Although the judges were responsible only to the law and themselves, the Army's Office of Chief Counsel, the OCC, had oversight of the subsequent proceedings. In relation to defendants charged with being members of Nazi groups found to be criminal by the IMT, the OCC pressed civilian judges to find that membership equaled guilt, even if the accused was able to document efforts to resign and escape the illegal group. The subsequent proceedings in the Justice, Farben, and Ministries trials rejected the OCC's advice and instead applied a functional test that considered the accused's actual relationship to the outlawed group. There were some of the outlawed group cases that were bunched with other charges in the subsequent proceedings. Well, the 12 subsequent proceedings were tried from December 1946 to October 1949. Now, they were initiated on the 21st of November, but the first trial didn't come until 13 months later, from December 1946 to October 1949. Of the 185 individuals indicted, 177 went to verdict. 4 defendants committed suicide and 4 were severed due to their illnesses. Of the 177, 142 were convicted of 1 or more counts. 35 were acquitted. 20 were sentenced to confinement for life. 24 death sentences were adjudged and confirmed. How then to explain the lack of public awareness of the laudable work of the subsequent proceedings? How to explain that what was to me the apogee of military trials in which a defeated enemy received the closest thing to justice that America has seen in post-war trials? Some of you may have seen the 1961 movie Judgment at Nuremburg, which is a portrayal of the subsequent proceedings justice case, in which 16 senior German jurists were tried. We saw that in the second talk this morning. Much of the movie's courtroom dialogue was taken from the proceedings record of trial. Seeing Maximilian Schell play a German defense lawyer and Burt Lancaster, an accused Nazi judge, is what first interested me in the proceedings, the subsequent proceedings. If you want to read a scathing indictment of lawyers, Nazi lawyers, try Judgment at Nuremberg. by Abby Mann. You can get it in paperback from Amazon for, I think it's $12. The tribunal's chief judge, Spencer Tracy, in the movie, had much to say, fictional or not, about the subsequent proceedings' effort to stay as close as humanly possible to justice in the face of horrific Nazi injustice. No movie can explain how only 10 of the 24 sentences to death were carried out. The initial 10 were executed with some rapidity. As time went on, General Clay began to look more carefully at these. Not more carefully, that suggests that there was something wrong with the judgments, but instead he was involved in the politics of the subsequent tribunals, of the subsequent proceedings. And he realized the ground was shifting under the U.S. position, even as the trials were continuing. 8.5 years after the last tribunal was closed, despite 20 sentences of confinement for life, every accused but the 10 who were executed were free men, beneficiaries of the West's fear of the rise of a Soviet Union and the U.S. desire for a strong European ally who might stop or slow any Soviet military adventurism. There were also other political factors in play. There was tremendous pressure on General Clay from German Catholic and Protestant clergy to reduce or set aside war criminal sentences. The Federal Republic of Germany achieved statehood in 1955, and Chancellor Konrad Adenauer pressed for war crimes clemency or outright release of those who were imprisoned. He was facing an election. The U.S. helped him out. Starting in 1951, the focus of the U.S. effort was no longer on punishing war criminals and re-educating the German public, but rather on preventing the war criminals' problems from causing further criticism of the American occupation of Germany. During this period, American officials instituted clemency and sentence modification procedures, which eventually allowed the complete dismantling of the war crimes operation. This latter phase was closely connected to the 1950 decision to rearm the Federal Republic of Germany and to negotiate to establish the European Defense Community. Were these releases, commutations, and reductions in war crime sentences worth the price? Did a firm and rearmed Central European ally merit what seems to be an abdication of World War II's resolution to punish Nazi war criminals? Well, regardless of one's opinion, the work of the subsequent proceedings was completed well before the political winds had changed. Lacking currency in the public's eye and without popular media following like that of the IMTs, the subsequent proceedings were lost in the rush to post-war security and European rebuilding and resurgence. The subsequent proceedings were not the forgotten trials, but they are the unappreciated trials. Thank you.
Do we have any questions for Professor Solis from the Zoom audience? How about in Decker Auditorium? Any questions for Professor Solis? We have a question from the Zoom audience.
Yes, sir. Just real quick, I was curious what the jurisdictional basis was, especially for the, I think it was trial 3, and then the proceedings against industrial leaders. What's the justification for taking jurisdiction over, you know, those individuals kind of doing offenses internally against their own people?
What was the justification for making them one of the 12 trials?
The jurisdiction itself, like how did the U.S. have jurisdiction to try them?
Well, we had jurisdiction Under Control Council number 10, which was the law of Germany until Germany could itself resurrect its own legal system, said that the subsequent tribunals could determine which crimes constituted war crimes. One of the crimes that they decided, one of the events that they decided was a war crime, were those who enabled the building of, for example, crematoriums, rocket launch sites, those who had provided the engineering expertise, the construction expertise of buildings, structures that were instrumental to the conduct, the rise, and operation of the Nazi regime. So you had individuals like Albert Speer, who was extremely close to Adolf Hitler, and who, as a civilian, wore military uniforms throughout the war, and whose expertise continued throughout the war and even beyond the war. And having decided that this was one of those occupations, within the sphere of occupations that conducted Nazi propaganda and allowed Nazi operations to flourish, they decided that they had to keep in mind that what they were trying to do was show the German people that there was a broad base of individuals who were to blame for their situation, who had caused or enabled the rise of the Nazi government. And they wanted to make the point that it wasn't just the military, it wasn't just the politicians who had sold out the citizenry, but it was people like Albert Speer and other industrialists, those who built the, as I say, the concentration camps, the killing camps, and the monumental Nazi structures that were throughout Germany. So, you know, it's not the firmest base of a prosecution that one might want. I mean, it's not the traditional, this is a criminal act, everybody recognizes it as a criminal act, but it seems to me that it furthers the goal, the justifiable goal, the laudable goal of the Allies to re-educate the German nation, which, by the way, was not an immediate success. But nonetheless, it was an effort which I believe was justified and commendable.
We'll look to Decker Auditorium. Yes, Mr. Bork, sir.
Thank you. Professor Solis, back to Vietnam and the Medina case. So you told us that the instruction was the wrong instruction. It was known as opposed to have known or should have known. But since Medina was an acquittal, which means no record of trial, how do you know what the instruction was, sir?
It's an interesting case. I know because the prosecutor, who is an individual I've been on many panels with over the years, he's now a retired law professor of the University of Kansas, told me about it. And even better, he wrote about it. He wrote an article for the University of Kansas Law Review, which, if anybody's interested, I've got a copy of it, as a matter of fact, in my briefcase. You can find it. And he says that he asked for that instruction. It is apparent to me upon reading it that he had received some criticism for that, and his paper was in part, in my opinion, an effort to justify the giving of that instruction. But he says that he gave it to the judge. And the judge himself, Colonel, I don't remember, Kenneth Howard. Colonel Howard gave a lecture. I meant to bring that as well, but couldn't find it. But he gave a lecture where he recited that Major Eckert had requested that instruction, and he, the judge, the military judge, said, "Are you sure that's the instruction you want?" F. Lee Bailey was the defense counsel for Captain Medina, and you probably would not remember his name, but at the time he was one of America's foremost defense lawyers. F. Lee Bailey said not a word. Sounded good to him. And Bill Eckert said, yes, sir, he confirmed that's what he wanted. Now, having been a military judge, if that had been my court, I'd have said, well, I'm not going to give that instruction. You got it wrong, counsel. I would have said something, but I wouldn't have given that instruction because it's simply contrary to the situation in the law. But Colonel Howard gave it. And we saw Captain Medina, who in my opinion was so dead guilty that it was just it was a wrong outcome. So that's how I know. But as you say, there was no record of trial.
Professor Soulis, thank you so much, sir.
My pleasure.
That concludes our second part. We will start the program after lunch at 1300 Eastern Standard Time. Please be back in your seats no later than 12:55.